But what's happening with bail? In many respects, in my experience thus far as a judge, bail can be one of the most hotly contested areas, right? Obviously, what happens at that bail hearing can influence greatly the outcome of the case thereafter. And while we have to balance the need to protect the public, we have many vulnerable people who constantly interact with the criminal justice system. How do we make sure that their bail hearings are not only effectively managed, just based on the procedural and logistical issues that we have to deal with? I know in Toronto have been very challenging, but also make sure that it's fundamentally fair. In that regard, as Maya said, we're going to cover some things today that focus on a variety of areas that we believe are commonly arising in these bail hearings. We couldn't possibly cover everything, even in a full day. That's not realistic. But in this opening section, I just wanted to go over some of the basics. All of these slides will be made available to everyone later today or tomorrow. So you don't have to write everything down if you're concerned about that. But if you're new, I just wanted to give everyone some of the fundamentals here. I mean, if you're not so new, maybe a refresher couldn't hurt. And we're going to talk about many of the subjects, obviously, that Maya gave you an overview of in particular. If you are new to this, when you come into a bail hearing, right, the first question to ask of the Crown is, well, what are your concerns? So you've got primary ground concerns about someone being a flight risk, secondary ground concerns, will somebody have a substantial likelihood of reoffending, tertiary ground concerns, well, with the public's confidence, the administration of justice maybe be compromised, right, if somebody was released. And then, of course, fundamental issues around the Charter of Rights and Freedoms that arise in all bail hearings by definition. In terms of youth, this was obviously an area I specialized in a lot when I was a lawyer, and I hope to do so now in my current role. We can't cover youth bail hearings per se. That's just beyond the scope of what we're going to do today. But I did want to flag that at the end of the day, time permitting, I'm going to take some time to talk about common youth issues that can arise in adult bail hearings. Just for example, what if the Crown tries to tender the accused person's youth record or youth outstanding charges? What if the Crown wants to bring a 524 application for someone who just turned 18 on the basis of an outstanding set of youth charges? What unique issues arise in that regard? And what should we keep in mind about the principles of the Youth Criminal Justice Act accordingly? So that's what we're going to do there. I would love to have taken another hour or two to do a full session on youth bail specifically, but we won't have time for that today. Maybe next time, we'll see. But if anyone has any burning questions in that regard, don't be afraid to ask me either. By way of the very basics, just in case you're extremely new, and this is the first time you've had such a seminar, remember that an accused person is supposed to be brought for a justice within 24 hours. The Crown can seek an adjournment of up to 3 clear days. Okay? Any adjournments after that typically should not be granted, subject to the consent of the accused. I know not always practice meshes with legal theory. And of course, there is supposed to be, or can be, I should say, a publication ban issued at the bail hearing. We're going to have a very interesting panel. I mean this, based on the preview session, maybe the panel of the day, with Kim Schofield, okay, about what you might consider if you're defense counsel with regards to publication bans and interacting with the media. Okay, and this is going to be very relevant for defense counsel who maybe are confronted with a topic that the press is interested in. I appreciate Crown attorneys have much less discretion or interest in this area, but I think it's something very, very interesting to look at as well. Evidence at a bail hearing. Again, if you're new to this, keep in mind that hearsay is generally admissible at a bail hearing, and the Crown can lead evidence, not just of what's directly alleged to have happened with the charges before the court, but of evidence surrounding the circumstances of the alleged offense and perhaps the background of the accused person, etc. All of that is contained right within the criminal code. I've just given you a snippet of some of the sections there, but if you're looking for somewhere to start just to orient yourself with these fundamental principles, that's where you'll find it. The Supreme Court of Canada obviously has given us a series of decisions on bail. I've included in the slideshow what I believe to be the highlights, the most important cases for you to know about. It was nearly 30 years ago, over 30 years ago in Morales, that the Supreme Court told us that pretrial detention is supposed to be extraordinary in our system of criminal justice. Query, quite frankly, if that remains the case. And then in a series of cases since then, like Antic and Myers, the Supreme Court has commented on the importance, right, of bail, of the presumption of innocence, and about ensuring that, quote, an enlightened criminal justice system takes these principles seriously. Importantly, in Myers, the Supreme Court also talks about the experience for people, of what it is actually like to be in pretrial detention. What does it mean? Not just that your liberty has been taken from you by definition, no, but you're cut off maybe from the outside world. It can be harder to manage your defense. And we're going to talk to some of our panels today about whether or not the conditions in a pretrial detention center are something relevant to consider at the bail stage, perhaps an area of some controversy, but some judges have weighed in on this, and I want to hear what our panels have to say about it. There were amendments brought into the criminal code in 2019, 493.1 and 493.2. I consider these to be very important. In the bail hearings that I have presided over, judges don't hear a lot of them anymore in 10 Armory, but we do hear some occasionally. I want to hear submissions on these sections a lot of the time, and I don't find they're often argued or brought up. But we're going to definitely spend some time with one of our panels today, including Justice Mirza of the Superior Court, to ask about these sections. What do they mean? How should they be applied? And what has the case law already told us? But I think they're very important for everybody to keep in mind and to focus on in any bail hearing where they could arguably be relevant. They're designed in particular, right, 493.2, to look at the particular circumstances of some of our most vulnerable peoples, including Aboriginal accused persons, but other groups who have historically been disadvantaged in obtaining release from the criminal justice system. What do the numbers actually tell us? Well, they don't tell us a lot of good things, I suppose. The number of people in remand continues to grow. There's different studies and some research that I've put in the slideshow just for your own reference. But in addition just to the raw numbers, various courts, including judges of the Superior Court in this province, have commented on the very difficult conditions in these pretrial detention centers, with one judgment there that I've included from Justice Malloy, characterizing them as simply inhumane, right? And what do we do with that, right? Because it's sentencing. If someone's endured particularly difficult conditions of pre-sentencing incarceration, that can be a mitigating factor that I or any judge should consider in crafting an appropriate sentence. But what do we do at the bail stage necessarily with this? Is it directly relevant, again, to the primary, secondary, or tertiary grounds? Is it not? You know, we're going to have a discussion about that throughout the day. Finally, obviously, and to all the crowns in the room, believe me, I know how difficult your job is when you're screening these files and making these decisions. Protecting the public is a serious concern. There are dangerous people who come into contact with the criminal justice system, many of whom arguably, of course, should not be released. But at the same time, there's also a great deal of research that says for many accused people, even a short stint of time in jail can arguably make them worse when they're released. If the conditions of imprisonment are so bad and someone is vulnerable, what happens if they lose their housing? What happens if they lose contact with the medical providers they need in the community? What happens if they're just removed from their support network more broadly and it has an impact on them? And then when they are released from jail, presumably after a short period of time, it's more difficult for them to reintegrate again. Well, what do we do with that? How does that factor into these difficult decisions as well? And we may spend some time on a little known decision called Nanabush, and I will say nothing else about that at this time. Okay, and we're going to talk to you about electronic monitoring. How can that be used or not? Is this a good use of technology? Is it not? Are there ways around it? But most importantly, I want everyone to feel free to ask the questions you want to ask, to have the discussion you want to do. And don't be afraid to challenge me or Maya or any one of our panelists if there's something you're really interested in.